AP. He is the Associated Press Arkansas and Oklahoma news editor, and because of some breaking news in Oklahoma, he was unable to make it today. Send his regrets, but we're glad to have Eric Francis here joining us, and that's why Eric doesn't have a nameplate, but everybody knows who he is. And moderating our next discussion is Roby Brock of Talk Business and Politics. And so, good to see you, Roby. Appreciate you.
I appreciate you. All right. So this was described to me as we would have couches and alcoholic beverages. I'm not seeing either of these things, so I would like to renegotiate our contract, please. Be fine. We're going to talk about, everybody here is going to offer maybe some tips and suggestions and take some questions from the audience, things that maybe haven't been touched on already, some things that you guys want to bring up. I know you've been answering some questions in some of the panel discussions that we've been having. So do we want to open up to the questions first, panel members, or do you guys, you want to go straight to them? Let's do it. Let's go straight to it. Questions that you hadn't had a chance to ask yet. Let's go over here.
As an elected official, I would prefer if somebody wants information, if they write this out, and I would have a record of what they exactly requested, not a broad terminology. Is that the way to go?
I'll tell you, you're a government official. Here's what I tell government officials when I do training sessions. If you can't control how they make a request, but you can control how you respond. So if somebody makes a request in person or by phone, it's best practice for you to reduce that to writing yourself and submit that to them and say, this is based on our conversation we had today in the hall, and you said this, and this is what I understand your request to be. And that protects both people, and you have a date on that for when it was recorded, and there you can extrapolate from that your response obligations.
And can I do a follow-up? We had a case where we were sued and attorney's fees were awarded for non-compliance with FOI, and the case was, the award was reversed on appeal because the court agreed with us. What had started out as an initial request for tell us about X through emails and other things ended up becoming 50 different requests, which creates a different clock each time. And so I think the advice that Ryan just gave is excellent. The other advice I will give you is make sure that you answer each one of those. I mean, you know, if you send the email out saying you've asked for a copy of the report of a dog biting at this address on this date, and they say, thank you very much, and what about the one that happened down the street? Then you've got to follow that up with, today you've asked for this, so that you always keep them separate. Because some of these can turn into multiple requests very quickly.
All right, we had another question right here.
Where is the law currently in regards to FOIA requests for social media accounts, private messages, or protected tweets for the accounts that are attached to these public entities? And just to everybody, custodians or people who requested that kind of information, what's happening when that happens?
Emails have already been held to be discoverable if they deal with government business. I haven't seen anything, we haven't gotten any, well, we've gotten Facebook requests. We've gotten requests for Facebook materials, and in those cases, you can delete and not really delete Facebook. I don't understand that, but you can recapture some of that, and if it's dealt with you know, public business, then we try to do that. I think that's one of the things that a task force on the digital age is going to have to look at. And I think that FOI and what is a meeting is going to have to be looked at in that regard too. We've got one commission right now that I'm getting ready to write a very polite letter to, and I apologize for my earlier comment, that's going to tell them you can't sit back and send this slurry of emails to 3 or 4 people and say, well, I think we ought to do this, I think we ought to do this, I think we ought to do this. Well, let's agree to do this. Yeah, that's a good idea, without conducting a meeting. And so I think that those are difficult areas that are digital that we didn't have in 2000. I don't think I had email even at the city. And so those things have got to be answered. But right now, thanks to Carol Griffey, the statute says data compilation in any form. And in any form, for a statute to be liberally construed to meet its ends, to me means Facebook, Twitter, all those other things, if they exist, are acceptable, are covered.
Anybody want to add to that?
As far as the Facebook and Twitter, I've never made a request for either of those. I don't know that anybody has. That was more one of, I think it was Tom at a different one of these things referred to FOIA as a 1967 cake with 2,000 icing on it. And it was, because it really hasn't, the way things are phrased and what you can ask for and what's available hasn't evolved, as the years have gone. The exceptions have kind of evolved. So you have exceptions now that exempt things that didn't exist when the law was even put in place. But we haven't updated, the available materials to really have any sort of guidance on those.
All right, I know we had some other questions. Yep, right here, and then we'll keep working our way around.
Mr. Campbell had mentioned that you had requested records in a specific, word. We haven't had any that have been that specific. They've asked for records in general. And we typically turn this into PDF, although if you have the PDF, you can still change documents if you're that mindset. But it's kind of a safeguard for us to prevent tampering, to turn those into PDFs to send them. If they ask for it in Word, are we required to send it to them in Word? Because it seems like that's opening yourself to going, here you go, do what you want to.
Yeah. So how do you guard against that?
Yes, you are required to give it to them in Word. Probably because it was created in Word. I mean, you are required to give it, remember, you're required to give it in the format or the medium. That's the FOIA, the terms format and medium are terms of art that are defined. You're required to give it in that medium, and you're talking about electronic information, so you got to give it electronically, and now we're going on to format, and here it's Word format. That's how the electronic information is arranged, and you got to give it in that format if it exists in that, and it does. In terms of concerns about tampering with it, well, I mean, you already said yourself, you hand over information and you know it could be tampered with. This is one issue, for example, when the Arkansas Supreme Court stopped publishing in a bound volumes their opinions, they had a real concern. One of the issues in implementing their electronic, the way they publish it now, one of their concerns was just that, authenticity. What will people cite now? Because before, there are these services like Westlaw and LexisNexis where a lot of lawyers use to get their case law. But there are a lot of typos. Like, for example, if you read our opinions in Westlaw or Lexis, don't believe all those typos, go to the real deal, because the typos are not there. Well, in the case law example, what's the real deal? Well, they implemented a certain thing. So each office, I think, needs to maintain this is the official document. And if ever there's some weirdness that arrives later in terms of authenticity, you can pull out the real document. And I just think that's unavoidable.
Anyone else want to add to that? All right. We had another question in the back of the room. Sure.
The first one is, I think you all alluded to the FOIA, if it is not stated in the requester's, request, that I didn't hear what you actually respond to that if this goes in. If the requester has to say FOIA or Freedom of Information Act in order to respond to any kind of action. Otherwise, it's a general information.
Let's let Mr. Sadler handle this one. So,
If a citizen of the state of the statute says any citizen of the state of Arkansas may request. That's the triggering mechanism, in my opinion, that starts that search. Well, what's the difference whether you walk into the office today and say, I'd like to have a copy of a particular investigative file versus I want it under FOIA? I'm still obligated to at least answer your question and tell you whether or not it's available. And if it is not, then I have to articulate why it's not. Does that answer your question?
But then you do get a differentiation between, like, responding to it and then trying to capitalize, and you have to turn it over immediately or within 3 days given the amount.
I think she's wondering if do you have to specifically say you're asking for it under the Freedom of Information Act for it to trigger the time period?
To
Or
trigger the time, sure.
if you don't say Freedom of Information Act, does that time period still trigger?
But if
in
it's
your
a
mind?
reasonable request for a single document, we're going to do what we got to do and, you know, we're not going to treat it as an FOI. It won't be logged as an FOI, but it'll have some notation that we did provide you a copy.
You sure can.
Okay, the other one is, when it comes to creating a document, I think it says in the Freedom of Information Act that we're not required to recreate or create a document. Is that correct? We don't necessarily have to, this is the request to do that. Do you understand what I mean?
Go ahead, Elizabeth.
I'm Elizabeth Walker in the Attorney General's office. I'm sorry I wasn't here earlier today. But the FOI applies to records, and there is no requirement that you create a record in response to someone's request. And so oftentimes people, it's kind of a misnomer. It is the Freedom of Information Act after all. So, and particularly people who are not very knowledgeable of the act really applies to records, maybe making a request makes it more sound like, well, I'm asking for information. They're really asking for records. But you don't have to answer questions in response to an FOI request. If there are records that contain that information that they're wanting, then you do need to provide those records. But you don't have to compile information and create a record. Does that make sense? You can. Yeah, it would be discretionary on the part of the custodian. And frankly, sometimes what we see is it may be beneficial to custodians, depending upon the request, to go ahead and compile that information, particularly, I think, in the area of employment-related records, where the alternative is if the person is dogged and really wants to know how many people were hired during this period of time. You know, the alternative is they can go through each of those personnel files and all those personnel records and compile that information themselves. So that's going to take a whole lot more time for that custodian to make those records available. And that's, you know, that's open information. There would be no exemption for that. So why not go ahead and compile that information and give them what they want? Is that technically required under the Act? No. But oftentimes it makes sense to do that. From the custodian's standpoint. And then, you know, my only comment about the FOI really here would be, and we see this so much when we travel around the state in my office talking to people, is this rule of civility, you know, and the idea of communication back and forth. I think one of the panelists when I walked in was talking about that, and the benefit of just understanding what the person wants, and the person from the requester standpoint sensing and having some confidence that you are working with me to try to get what I want. You're not being obstructionist. You know, you're not saying, well, I don't have to compile that information and create a record. You know, that just puts the person off, and then they feel like you're just not really trying to help them out. So, we think those are kind of requests that many times should be handled that way, although technically they don't have to be.
I'd like to hear from a little bit of everyone too before we go to either a follow-up or the next question about this civility topic here. Kind of rate the majority of the requests that you get when you're dealing with them or that you might be making. Are you usually dealing with someone in a confrontational manner, or are you usually dealing with someone not in a confrontational manner? We'll go Bill and come back this way.
It's amazing. When I came to the state police 16, 17 years ago, the number of FOIs that were coming in were probably 90%, 80% news media request and public, a few public in there, just general public. Today, I would, without looking at the numbers, 90% of the request come from legal counsel. And so it's the tables have turned a little bit. Is that confrontational? Is that adversarial? Well, that lawyer knows the law just as well as I do, and my legal counsel that I lean on for guidance. So the law is very plain, and we're going to follow the letter of the law and the spirit of the law.
We'll just work our way down. Anybody that wants to comment on that subject. You already did, Elizabeth. I don't know if I give you another chance there.
Well, as a professional requester of information under the FOI, what I try to do and what I try to encourage public officials and agencies I interact with is not to take this personally. It is, especially from my point of view as a journalist, frequently an adversarial relationship, but I'm not requesting this information to make you mad. I'm not requesting it to inconvenience you. I'm requesting it for a specific purpose that has really nothing to do with you personally. And I understand sometimes it's going to be inconvenient or aggravating to respond to my requests, and I'm not going to take that personally from you either. I think if we can kind of quash slightly our personal aggravations and work together as professionals, we're both going to be able to get through our day a lot more quickly. I will get the information I need. You will have helped out a journalist or a resident, and we can all move on to the next thing in our lives. It's a little bit of a balancing act, but if we all try not to take it personally and we just smile and shake hands when we're done, I think we'll all be a whole lot happier.
I have fielded calls from custodians where the clear tenor is, what can I do? How do I not respond to this guy? And that approach from the part of the custodian, it goes against actually the terms of the FOIA. You know, people talk, well, what's the letter of law? What's the spirit of the law? The FOIA actually makes the spirit the letter. If you actually read it in your blue book, and it's 101 or 102, where it says this shall be interpreted in this way. And one of those I talked about earlier is that you narrowly construe exceptions. So you don't go exception hunting. But on the other side of it is, for the requesters, if there is an exception, the custodian is bound to that exception. And they're not trying to necessarily, stall you or be obstructionistic or make life hard on you. They're bound by both, on the one hand, the obligation to disclose. There is an obligation to disclose. And that's the rule I said earlier. If it is a public record, you must disclose it unless it's exempt. That's in 105. So they're on that side of the rule, you requesters. The custodians are on that side, but also on the other side, the exceptions keep them from disclosing certain other things. And so they have to walk that tightrope. So on the part of custodians, I say, don't hunt for exemptions. If they're there, you have to use them. On the part of requesters, I say, not every public custodian is out to get you.
I guess my answer varies slightly depending on whether I'm requesting sort of in capacity as a lawyer or as a blogger. But in general, I try to make my request just sort of as dry and bland as possible, and then kind of leave it up to the custodian to determine how that relationship is going to go from that point.
So you don't find any, advantage in being nice at the beginning, and it's cut and dry to you?
Pretty much. I mean, I try to, pursuant to the Freedom of Information Act 2519-101, and then list what I want. Say, request it within 3 days, electronic format if you have it. If you have any questions, please give me a call, and cell phone number. That seems to work the best in terms of getting a pretty prompt response, either in terms of we're not giving you that, or somebody say, oh yeah, we'll have it to you in 3 days. And
everybody responds within 3 days to Matt Campbell too, by the way, right? Yeah.
I wouldn't go with everybody, no.
Did you have another question back here? Yeah, no, you have as many. All right, so the question is that is there a limit on the number of requests that a requester can make? Because too many can be harassing to the person that has to fulfill the request. Is that fair enough? Yep.
I'll go ahead, Roby, because when I spoke to the county association last weekend, a group of justices of the peace at their annual meeting, and I don't know how many times this particular JP, this county, had this person make the request, but it was for 25,000 documents. And the person kept coming back for the same documents. And understandably, this county official was very, very frustrated. The FOIA does not itself speak to any limitation on the number of times records can be requested. So the best I could really tell this county official was, get with your county attorney. I can't tell you at what point I would anticipate a circuit judge being receptive to an argument that this is purely harassment. This person has been provided the records. But I think there is a line that will get crossed. There's no reported case that I'm aware of where the Arkansas Supreme Court has said, X number of requests, and there never will be, and there shouldn't be. That would not, I don't think, work under the law either. So it wasn't very satisfactory answer to him, except for maybe some practical advice of document this and the number of times you have satisfied the request, and make sure you're dotting your I's, you're crossing your T's, you're doing everything you can to be compliant. And then at the point where you just know this is, over the line. And you may have to go to court over it. If this person is that unreasonable, it's doubtful that anything is going to speak to them short of a court order. So you might actually have to go and be proactive about it and seek a protective order, unfortunately. I just don't know if that's been done yet.
All right, we got a question down here.
So the redundant request must be fulfilled. And so if I want to request a manual that, say, has a cost for you of $24, and I want 2 of them, I should make 2 requests and avoid a payment.
I wouldn't treat it that way. If you came to us and asked for a copyrighted document, like a book, and you wanted a copy from us, then what I would say to you, and it most comes up in terms of transcripts of depositions, I would say to you that there is a rule that tells court reporters how much they can charge per page, and then there's our copy costs, which are sort of minuscule. So you're going to have to pay us the 2 cents a page for the 100 pages, which is $2, but you're going to have to pay the court reporter $300. You might as well just go to her directly. If it's a book that's copyrighted, the FOI doesn't require you to violate a copyright, so you can't ask for my version of War and Peace and expect to get 2,000 pages for, a lot less than you can pay for at Barnes & Noble. One of the issues that's coming up on the digital age is if things are available otherwise digitally, can that be a proper answer? If you want a copy of certain code enforcement regulations, and the book costs us $195, it's not a short amount, but you can get it from the website for that group, are we going to be able to start saying go to the website and get that? And I don't know the answer to that part, but I can say that we don't have to violate a copyright just to comply with FOI.
I would slightly disagree with the analysis of the cost on that. I think it's a pretty good argument to be made that once that deposition transcript has been paid for with city funds and the city has a copy, I'm entitled to it, to a copy of it at the 2 cents a page. And I mean, there's AG's opinions on everything from, it cost us this much to get all this information on CD-ROMs, and this person wants a copy of it. Can we charge them what it cost us? And the answer was no. What it cost the city to get something in the first place isn't the cost of reproduction, and that's all that you can charge.
Right, but the problem I've got with what you're saying, and I'm dealing with depositions only, I'm not expanding this out. Depositions and what can be charged for them are covered by a court order, and there is an exemption under FOI for something that's otherwise covered by a court order, and that's basically where we come from on that. And that's, I mean, I use the deposition because the court reporter's position is the producer of the deposition. I mean, the city hasn't produced it.
No, but the city has it as otherwise kept, and the city becomes a custodian at that point.
Well, we keep it, but
So it's otherwise kept.
But even so, technically, we're not supposed to be able to go off and just keep making copies of it and sending them out. That's taking money from the court reporter from some court order, and I don't think I've got that authority.
I'd like to add something that has arisen at state police, and it was rather shocking to us. Several years ago, we put the Arkansas driver license study guide online. We thought I mean, this is a slam dunk. And because, okay, most people taking a driver's license test they're 15, 14 years old, but we still are handing out the little red book by the thousands every year. People still want that book. They don't want to go online and read it there. So we still have to provide the book.
All right, other questions from the audience? Yes, sir.
So, I mean, other states, of course, have their own FOI acts, correct? Do any other states have task forces that regularly check up on that state that's adapting to the law?
The question is are there other states that have task forces that are checking on updates to the FOI law?
I don't know about task forces in other states, but I know this. I know Congress held hearings on the 14th of March on this issue of this year. They held hearings in 2011. The RAND Corporation has just published a document on FOI in the digital age, and I think what is happening is that states are beginning to recognize the kinds of problems that have been created. I don't know, if any state does, it would be North Carolina, but I don't know of any state that has an ongoing task force. But I think he's right, because as I understand it, if I buy a computer today at Best Buy, before I get out the door, it's already dated. And with the technology changing that quickly, something's got to be in place to help deal with the act.
Let me just make two comments about that. It's a matter of fairness on the part of both the requester and the custodians, because the custodians are under potentially criminal obligations for not responding properly to FOIA requests. And on the part of the requesters, it's fair for them to have certain reasonable expectations what they're going to receive and when they're going to receive it. And if the law is not keeping pace with the facts, then everyone's expectations are going to be upset, and people are going to be on the line for legal violations, and people are just going to be regularly upset. That's the first point. It's a matter of fairness, I think. The other point is, most other, like for example, there are rules of evidence, both at the federal and state level, rules of procedure, rules of appellate procedure. There's all these different rules, and almost every one of those has a committee that's standing, that regularly reviews the matter, regularly reviews how facts are changing, regularly reviews how laws need to be, and they make recommendations to the body that has the authority to make changes to the rules. And the FOIA is very similar to those underlying foundational rules, like rules of evidence. Everybody has to comply with the rules. Everybody has to comply with the rules of civil procedure and evidence and so on. And a similar thing with the FOIA. It undergirds all of the public organizations and some private organizations. So it seems to make sense that given the way that the rules are treated and how expansive they are in the sense that they apply to everybody, same thing with the FOIA.
Matt's been reading through the book there. Are you going to go back to your previous argument? Okay, well, not right now. All right. Other questions that we've got? Yes, sir.
Ron, what's custodian?
Custodian is someone who... the court has said that custodian is someone who has administrative control of a document. And they made that, which you might say, well, what does that mean? Right, you go to a dictionary to look up the word and it says a word you don't know what that means. It's sort of like that. They designed that explanation of who is a custodian to say you don't have to have physical control of the document in order to be the custodian. If you have the ability, this is the rough rule about it, you can push it to where areas that it's not, you have incorrect results, but if you have the authority to direct someone else to give you the document, then you may be the custodian.
Do you want to add to that, Eric?
Years and years ago, actually in a discussion with the state police, I think it was after you were there, but I was with a group of journalists and we were introduced to someone at the state police who was designated as the custodian of the documents for the purposes of FOI. And then my argument was the agency is the custodian of the documents, because if the person you've named is on vacation or in the hospital, does that mean I can't get my documents?
So I'll speak to that. I think it's really reasonable for everybody if a single person in a large organization is designated as the custodian, and to deal with what he just raised, which is a legitimate point. That the person goes on vacation, there needs to be a substitute. There needs to be a person who fills in while that main person is gone. And I know that that does happen. A person is designated as the main person, and they're gone, and they say, sorry, they'll be back from Florida next week. That's not a legitimate FOIA response. But it does help everyone. It helps the requesters, and it helps the agency when there's a single person who has developed subject matter expertise and relationships in how to respond to FOIA requests.
At the same time, I have frequently argued during my career that any person in an agency who has a legitimate reason to have a given document is the custodian of that document. And if person A, the designated agency custodian, isn't there, I should be able to go to person B and get the document.
Well, and there's a statutory requirement on the entity, whether it's a city or an agency or a county or whatever, that if a request is made to somebody who is not the custodian of the documents, that they've got to get the request to the custodian of the documents. So I'm not sure who is the custodian is important. I mean, a personnel report is at HR, or if it's a police officer, is at the police department. I really don't care. I'm going to shoot it to somebody and say, we have referred this to HR and to the police department, and this is what they're entitled to, and that's how we deal with it.
Did you want to add comment to that, Bill?
Since he mentioned state police, and in order to exercise the checklist that Ryan noted in his first comments, because there is such turnover sometimes in those record sections, a personnel clerk in a file room, he or she may not have any idea of what the exemptions might be that would be applicable. So while technically that clerk holds the key to that filing cabinet and that room, there still has to be somebody, I think, at an agency that is the clearinghouse. And in the case of the state police, while I'm not identified necessarily as the custodian, all the FOIs do at least cross my desk. And I may ask the personnel office to pull that file, start working on it, and then myself or Greg Downs, our chief legal counsel, will look at it and see if it meets the criteria as they have maybe prepared it.
It was such a simple question. Who is the custodian? Look at all the debate that you sparked from that. I think did you want to add some more to it? I think we still had some more comments on that.
The other part I would add is for you as a requesting party, the easiest way, because of the clause that Tom was talking about, is shoot it as high up the chain as you can. I mean, like everything else, it rolls downhill. So if you don't know who it is as an agency, a lot of times with some of the state level agencies, you can find that information online and they tell you where to send it. But if you're trying to get something from a municipality, send it to the mayor and he'll make sure the right person gets it. And at least then, in theory, the entire municipality is on notice if you're going to the mayor first.
All right, I saw another hand up right there. Mm-hmm.
Well, being with the municipality, it also makes me on the defense that as the custodian, many of these large requests that we get are for records from multiple departments, board of directors, all of these different entities that I have to collect it from. And I can ask my board for their records. When they give them to me, is it supposed to be in 3 days? Yes. And I can go after and go after and go after. But as a custodian, I cannot give you the information you've asked for until I have it. And I know that we've had that 3 days, and we've told our board, and we've told department heads. So it's not that I'm being disgruntled and, not open. It's, I don't have anything to give you yet. So I think that being nice on our end, maybe, make it nice on their end.
And as somebody making a request, I think it was mentioned earlier today too, if you called and said, hey, this might take more than 3 days, and just kind of keep the communication going. I mean, I can't speak for everybody else, but I'm not going to have a problem with it. I had something with DHS a few months ago, and it took 2 weeks to get everything because there was that much information. But they were really good about every couple of days kind of calling and updating and saying, well, here's where we are with it. We're waiting on this. And that's fine. Just keep the communication going.
Do you want to add to that, Eric?
I would say that I certainly empathize with you because I've made large requests spanning many departments in a city government before, and there needs to be a little give and take here. I'm absolutely with Matt. I need to work with you. I need to give you plenty of time for a big request. But on the other end, someone, maybe not you, maybe the city attorney's office, maybe the mayor, maybe the municipal league, needs to educate everybody else in your city that, there are times when this request comes in and it has to be filled within 3 days. And you don't have an option, whether you're a department head or a city board member or what have you, of putting that off. And if you can then add to them, and these guys work with me, do you remember that big request from a month ago? It took us 3 weeks. He had no problem with that. And I think that will, it goes back to my comment about playing well with others. If I work with you, that's going to give you and the people in your city a little more incentive to work with me.
Yeah, I can even tell you too, I've gone to make a large request before and just went and sat down with the public information officer first to figure out how we could do it as efficiently as possible. I know that doesn't always happen, but before I even made the request, I needed to understand the whole scope of what we were asking for so that we could find a way to really narrow it down for what the request was. And I think the PIOs primarily, or the agency heads, are pretty receptive to that. Yes, sir.
From a technology standpoint, I know I've recorded a lot of meetings, for people that have tried to record them, save as MP3, easily accessible. Do you think the task force could look at maybe standardizing some of those formats or procedures and metadata so everybody, from the requester to the state agencies, it's just easier and more time, less time?
It's hard to, one of the things that FOIA has steadfastly not done is demand that records be maintained or stored in a certain way. For example, there's nothing in the FOIA about how long certain records have to be stored, or data retention. There's nothing in the FOIA about how your meeting itself has to be conducted. For example, do you have to have a motion in a second, and whether Roberts will. So the FOIA has attempted, and I don't know whether it can continue fully in this way, but the FOIA has attempted to kind of stand off to the side and just say, if you're going to do this, you're going to have to turn that over. You're going to have to turn that document over. If you're going to make this, you're going to have to turn that document over. So in terms of the FOIA itself, requiring certain records be created and maintained in certain formats, I don't know how feasible that is, but I'll just say historically the FOIA has not done that, tried to not do that, even deliberately, I think.
And I will say as a requester, I love that idea in theory. In practice, as another Mac user, I know that it's possible that whatever city or state I live in might decide to use a certain word processor that's only available for PCs that doesn't translate well to Mac. And if that means then all of my documents are going to come to me with extraneous characters in them that I have to somehow filter out, that's going to be hugely inconvenient. Maybe there will be a grand unifying theory of data storage at some point in the next decade that would solve this problem. But I empathize with you, but I think it's just we're not quite there yet.
And the FOIA does right now attempt to address this concern when it talks about when custodians are under an obligation to take some video that's in a certain format and turn it into a different format. It attempts to address that. How well it addresses that is a different matter. And that's more to the question about this task force and people updating this. But there are the tools sort of latent there to deal with that concern.
And the day after everybody homogenizes their method of keeping electronic data, someone will invent a better way that's not compatible with your platform.
Mm. All right, yes, question over here. Is the custodian ever within his or her right to refuse a FOI request?
Sure, if it's a clear exemption. The primary example is going to be, I want to know what Tom Carpenter's medical records show in terms of a heart condition. Well, you're not going to get that because that's a medical record, they're expressly exempted. But the entity needs to tell you you're not going to get it and that it's expressly exempted. terms of the outstanding balance, I don't think the custodian can do that. I mean, I think if you make a request and each request is a new request, even if it's for the same stuff. And the remedy for going after you for not paying the money for the last request is to file a small claim, or if it's a large amount, file a large claim. There is a legal remedy for that, and it's not to ban access to FOI. In terms of the information is insufficient, I mean, that's a difficult one to answer because what's insufficient for you may be totally compliant for me as the government. And if you ask it in a different way, but you're basically not expanding or changing what it is you've asked for, then you may get the same stuff again. Now, you know, if you didn't get the phone call and said, we already gave you that the last time, do you really want to pay for it again? That means that you're a pest and we're not going to be nice to you anymore. But the fact of the matter is that if you ask for, I need information on this address for this time frame, and you get that, and then you expand the time frame, then you should get the new information. And if you don't, that's an FOI violation. The fact they gave you information before doesn't make any difference.
I would say too, to the money part too, just from a requester standpoint, I typically will always ask for something in the most cost-effective manner possible, and I'll almost always ask if a fee, what the fee might be associated with it, just to have that clarification on the front end. Y'all may have covered some of those tips earlier. Any other questions?
And recognize something about today's world. For those entities that can give it to you in a PDF or by email somehow, it's a lot easier for them because you may not realize it, but when you go to the state of Arkansas with a 24-cent check, then it probably costs the state $3 or $4 just to be able to process that check. And so there's an advantage to the government getting it and saying, if you can send it to me electronically, please do so.
Are you advocating that you shouldn't charge anybody less than $3 for an FOI request?
Well, we only charge 2 cents a page because that's what it works out for copying and ink and everything. You can't charge for the amount of time. I have always been amazed by the people that continue to charge 25 cents or 50 cents or $1 a page because I don't see how you can do that under the statute, and the attorney generals have been quite clear that you cannot do that under the statute.
Yet it still happens. All right. I'm going to give our panel one last chance to run through anything that wasn't discussed today that you think should have been brought up today. Matt, you get to go first. And don't go back to that Tom Carpenter argument again. You can do that after we're done.
I think pretty much covered everything that I was here to talk about. The only other thing that I might add, sort of piggyback on what Roby said as far as asking if there's going to be a charge, you can also, when you're making your request, say, you know, hey, if it's going to be more than $10, let me know before you start making copies. And custodians tend to be, you know, they like that sort of on the front end because then they don't make 5,000 copies and think you're going to come pick it up when you had no intention of spending, you know, $500 or whatever it works out to.
I don't really have anything to add. I've done a lot of talking.
We have a great FOI in this state, but I sit on the Press Association's FOI Coalition, and it is gradually being nibbled to death by ducks. Every session, bills come through that contain little bitty exemptions to the FOI, and that has a cascading impact because the more exemptions that are allowed, the more are sought. And then you wind up in a situation like Tennessee, which had a fabulous FOI that now has more than, I think, 200 exemptions to it that weren't in the original bill. So please be thoughtful about the health of this law because, as the Supreme Court stated in Layman v. McCord, it was enacted wholly for the benefit of the public. And when you hear people, especially legislators, no offense if there are any in here, talking about needing another exemption for something in the FOI, you know, stand up and say why, because how does that benefit the public and not whatever special interest may be behind this piece of legislation?
I want to do a follow-up on what you said. I wasn't going to say anything. The Arkansas FOI, I think, is the most liberal in the country. Attorney-client privilege is not recognized in Arkansas with the exception of meetings. And there's no place else in the country that has that. You get access to records here that most states would not even think about letting you have access to. You get it within if you can define the difference between immediately, if not in use. I mean, I'm trying to figure out, you're either using it or it's in storage. You know, I mean, if it's in storage, you got up to 3 days. If it's not in storage, you're using it, it's immediately. I mean, that's how I interpret it, sometimes to the chagrin of some of the officials I work for. But I think the whole act has to be totally overhauled because the world is different. You mentioned Lehman versus McCord. Lehman versus McCord was the case that came out of the meetings part of it. It dealt with an attorney being able to talk to his clients about the settlement in a case without it being broadcast in public or having a situation where the opposing side could discuss the merits. The Supreme Court in Lehman said, well, we don't see that that's going to be a problem. We don't see that people are going to start using FOI for discovery and trials. We don't see that people are going to start seeking appraisals in condemnation cases and 3 or 4 other things that are really commonplace now. The problem is that if those from the government who need to deal with these things suggest that we need to overhaul FOI, then the news media goes into painful paroxysms about it. And the problem with that is that the news media isn't the group that's creating the problems for the government with FOI. I mean, that can't be said enough. With the exception of young reporters who think that they have to show me that they know more about the world than I ever will, and that only lasts for a week or 2. With that exception, the news media has always been exceptionally easy to work with, even when it's stuff that I haven't wanted to turn over. Big deal, I don't want to turn it over. That's not my call. The problems we have are a lot with citizens that will say, go out and get this for you. You spend an enormous number of hours getting the information together, and they don't pick it up. And then they ask for it again, and they don't pick it up. And you get tired of that. The FOI did not contemplate the digital age, and, you know, I mean, I'm convinced that within 10 years, we're not going to have cell phones, we're going to have, you know, chips inside of our skin, and we can just talk to our hand if we want to, which is better because with Bluetooth technology, I can't tell who's schizophrenic and who's talking to themselves. But be that as it may, that discussion needs to occur, and that kind of revamp needs to occur because a 50-year-old statute just does not cover modern information. And the reason you get little tidbit exemptions is because nobody's wanting to take on the 50-year statute because the news media will say, oh, this is the most horrible thing in the world. And the government isn't listened to when they say, but we're not worried about you. I'm worried about so-and-so. I mean, it took the U.S. Supreme Court 2 years ago to finally say, I don't have to answer, it's okay for me not to answer the FOI request for somebody in another state. But you cannot imagine the number of times litigation has been threatened because I wouldn't answer it for the person in the other state. And I think that, you know, the Press Association and Sigma Delta Chi and the Bar Association and the various government associations, they really need to sit down and find a task force that gets rid of the true believers on all sides and then says, yes, the public has a right to know. And by the way, this is a pretty good act. You know, for all of the things that you can say that have been shown, Arkansas has had an incredibly good record against corruption. And so much so that when somebody decides to take several $1,000s in a cake or a pie box on a Saturday morning, we all sit there and go, where did this come from? And I think if we can get government people that accept that and government people that deal with it, dealing with press members, and Bill Simmons used to be my guru that I would go to, Bill, I got a problem with this, what do I need to think about? I think that we really could restructure something. And I think that Ryan is absolutely right that, you know, we've got to figure out how to deal with technology. And we're going to have to figure out technology now in a security age, which hasn't been touched upon. You want the videos from my police cars? Guess what? We go out of our way to record sounds in a way that you can't get to because we're trying to maintain a secure situation. That is a legitimate public need. If we have to turn everything over, then maybe we'll just stop recording things, in which case, we're not necessarily serving the public either. And I think there is a balance in there that can be found. I don't think it's something that they can start in January and have a bill by April. You know, it took 2 years, I think, for the last time that they tried to deal with digital media. But I do think that discussion has to occur.
All right, Tom's made us all hungry for pie now. Thanks, Tom.
And I think the timing is right for that. What I've seen in my 25 years plus working with FOIA is so much more awareness of the act. When Bill said about the state police, when you said you're 90% are now lawyers, I was really, which is probably using FOI as a discovery device, I feel certain. I felt certain you were going to say they're citizen requests, because I see such an uptick in knowledge and interest in the FOIA. And I was trying not to frighten those county officials last week, but that's really the message I wanted to get across to them. I said, I'm glad you're having me today at your annual meeting. I know you have some new people, coming on board. And knowledge, you just have to be knowledgeable of this law, because you may well have great intentions of not violating it, but it's so easily violated if you're not aware of it. And they knew that. And 15 years ago, I don't think that was really the case. And we wouldn't, when we were going around the state, it was hard to drum up people, have any interest of us talking to them about FOIA. So, and we see more and more cases going up to the court. We still don't see many prosecutions, but we still see a lot of cases. We see more cases going up. I think that's an uptick. So that awareness factor, to me, indicates the time is right for all of the things we've been talking about in terms of a task force and some looking at the act as a whole again.
I still have a mortgage, Tom, so I'm not going to stick my neck out as far as you did. First of all, I cannot imagine, forget being a state employee, I cannot imagine being a citizen of the state of Arkansas and living in this state without an FOI. It just makes sense to have open government, open records. And I want you to stop. I'm just looking at the room here. Was anybody here in 1967?
I was two.
Yeah. But stop and think about what was going on in 1967. I mean, and then in the end, I mean, we were every courthouse had ballots stuck under desk, and corruption was wholesale. But the thing of it is, in the end, it turned out that there was a unanimous vote in both houses to pass this law. So while I'm going to go down Tom's path a little way, yes, I think there does need to be some rethinking, retooling, and to representatives of the Press Association, news representatives in the room, I think you should step forward and become active in your FOIA coalition. I look at the Press Association today. It seems like it's shrunk a little bit as far as the people who are actively participating. But when you get ready to do this, because if you're not careful, it's going to be done for you, I'm afraid. Because we're living in an age right now where people are frightened, and there is a lot of emphasis being placed, a lot of pressure being placed on legislators in Congress that too much information is out there about me. And they're really not looking at it as the whole. They don't want information about me being out there. And I'm afraid that's going to be the driving force if you're not careful. And now may be the time for you to embrace different parts of state government, county government, city governments, bring everybody to the table and start talking about it. Because I'm afraid if you're not careful, it's going to be done for you.
All right, Bill, Beth, Tom, Eric, Ryan, Matt, thank you all for participating in the panel today. And let's give them a round of applause. I hand it back over to Aaron Sadler. Thank you all for all being here.
Just very quickly, on behalf of the Attorney General's office, I want to thank you all for coming. I appreciate our panel, our moderators, Cecily Pond Mayo, Roby Brock, this wonderful facility, Central Arkansas Library Systems, Ron Robinson Theater, our live streamer, Brant Collins. We hope to have the feed of this presentation on our website soon. We'll keep you guys posted. As you go out, there are quite a few FOIA booklets, the new 16th edition, so pick up as many as you need. Thank you all for coming.